It's 5 p.m. on Thursday, April 14th, and therefore you are at the bar. I'm Inez Stepman with the Independent Women's Forum.
And I'm Jennifer Braceras from Independent Women's Law Center. Welcome to our 25th virtual happy hour conversation about issues at the intersection of law, politics, and culture. Today, I am drinking a Cape Codder, a very nice New England drink, cranberry juice and a little vodka, to kick off a long holiday weekend. So today we are going to be talking about Title IX, the statute that most people think of either as a catalog for women's athletic wear or a sports law. And we are going to be talking about how bureaucrats at the Department of Education have twisted this law, which is actually just a simple anti-discrimination law, into a vehicle for social policy making on everything from sports and school dress codes to sexual assault and harassment. And we will discuss how in the coming months, the Biden administration plans to twist the law even further, beyond all recognition, some might say, and some people might argue that they're planning to gut it completely. So should be an interesting discussion.
Absolutely. And to join in that interesting discussion and help us break it all down, we're going to have two guests today. First, we're going to have Professor Shep Melnick, a politics professor from Boston College, and he's going to join us in just a moment. Later in the show, we'll be speaking with Candace Jackson, who's a former Deputy General Counsel at the Department of Education under the Trump administration. But first, Jennifer, let's just break this down, because there's this one tiny little statute, like basically one sentence, right? And it has spawned so many buckets of policy and regulation and things that impact our lives. So I'm going to post the graphic of the actual statute, which, bear in mind for all of our discussion today, this little tiny thing is what has generated all of these different sort of policy elements.
Yeah, so there it is. I'll just read it out loud, especially for those who are listening via podcast and can't see it. The law says no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So, in other words, if you are a school that gets federal money, and virtually all of them do, not just K through 12, but private colleges and universities as well, and public colleges and universities. So if you are one of those schools, you can't discriminate on the basis of sex. And not only can't you discriminate in the particular area where you receive the federal funds, you can't discriminate at all. So let's say only your biology department, for some reason, takes some federal funding for a research grant, but no other aspect of the university takes federal funding. It's kind of a false hypothetical, but let's just say that's the case. Still, that university would be prohibited from discriminating on the basis of sex in any aspect of its programming, whether that's athletics, admissions, housing, scholarships, whatever. So that's the law. It was passed in 1972, and it prohibits sex discrimination in education. That's basically it.
And out of that single sentence and very basic description that Jennifer just gave, we have elements that go into, for example, due process rights. When people are accused of sexual misconduct in college campuses, we have the definition of sex itself, all kinds of attempts to put gender identity under that definition. And then we also there's free speech elements as well, because this also deals with harassment at any institution that takes Title IX funds, which, as Jennifer said, is K-12 and universities, but it also deals with harassment and the definition of harassment, which has in recent years gotten really, really vague and started to sweep in potentially protected First Amendment speech. And then, of course, there's the thing that everybody knows, which is the sports element of it. So this one tiny sentence has just done so much work in terms of building the sort of regulatory civil rights era that we live under. But with that brief introduction, I think it's time to bring up our first guest. Arshep Melnick is the Thomas P. O'Neill Jr. Professor of American Politics, as I said, at Boston College. He's also the co-chair of the Harvard Program on Constitutional Government and the author of a book called The Transformation of Title IX, Regulating Gender Equality in Education, which was published by Brookings in 2018. Thanks so much for joining us at the bar.
Oh, it's great to be here. Thanks for asking me.
Yeah, thank you so much. Yeah, Professor Melnick's book, I don't know if everyone could see this, The Transformation of Title IX, is actually a really great primer for anyone who's sort of unfamiliar with the details of Title IX and also the administrative state, how federal agencies in general regulate based on laws passed by Congress. And I want to ask you a little bit about the book. You have a chapter in there called The Complexities of a Simple Statute, in which you talk about sort of how there are all there's, you know, as Inez and I just talked about, it's one simple sentence, basically, the main part of the law, but then there are all these exceptions to the statute. And you talk about the ways that Title IX is different from Title VI, which prohibits race discrimination in schools and other recipients of federal funds. I'm just wondering if you could talk a little bit about those complexities and why Title IX has all these exceptions that Title VI does not.
Sure. So let me start with saying something about the way in which Title IX came into being, because directly related to your question. When Title VI of the Civil Rights Act was passed in 1964, it said, analogous to the part of Title IX you read, that you can't discriminate on the basis of race or national origin. If you do, you will lose your federal funding. And federal agencies were given the authority to enforce this through termination of funding and by issuing rules and regulations. So they had enforcement power and they had regulation, writing power. Now, in one part of the Civil Rights Act, Title VII, on employment discrimination, the word sex was added. It's kind of an interesting, complicated history. But in Title VI, it wasn't. So in the early 1970s, quite a powerful Congresswoman, Edith Green from Oregon, wanted to add the word sex to Title VI. So it would affect educational institutions. The civil rights organizations opposed that because they didn't want to open up Title VI to amendment at a time when busing was such a hot issue. So she said, well, we'll just add it to an education amendments. Whole omnibus bills are mainly about funding. So part of the result of that was that it generated very, very little debate. The other part, this really goes more directly to your question, is that as much as everyone wanted to say the sex discrimination is like race discrimination, they made various distinctions, various concessions, because people realized it wasn't exactly the same. So concession number one was that private undergraduate colleges were exempt. So Wellesley can still be all women. Mount Holyoke can still be all women. And it's possible to have all males colleges if they're private and if they're undergraduate. And then they made the exception, said that for housing, you can have segregated facilities for housing. We certainly would not have done that for race. And there was exemption for religious institutions, for military institutions. So lots of exemptions from the beginning, and then later Congress added some minor things, like you can have all female choirs, and you can have mother-daughter dinners if you have father-son dinners. Not high policy making.
But all of those exceptions or complexities, as you call them in the book, are all really reasonable and just make common sense based on the fact that men and women are different. We are equal, but we are not the same, as Inez and I say all the time. Not so with race. Race is supposed to be an irrelevancy. There's no difference between a black man and a white man other than skin color.
Right.
So these exceptions make sense. What are some of the other complexities that you see having been sort of added
Sure.
by the department over the years?
Yeah, I mean the biggest difference, and this really goes to a big part of Title IX, is athletics, which you mentioned. So we expect to have separate male and female teams. To do otherwise would be, really unfair to women. We don't allow separate black and white teams. If the basketball team is almost predominantly black, there's no cause for whites to say, "Hey, we weren't treated fairly." The truth is, they just weren't as good. So that the biggest disjuncture between the race and the sex, in the analogy, comes with the fact that we allow separate but equal in athletics. And I use that term advisedly, separate but equal, because it shows how different it is from race. And then the question comes, what is equal? Equal number of opportunities, equal number of players. How do you measure equality? And we had to find some way of measuring that. And I will say that the way that we devised for measuring that, which is making sure we had equal numbers of male and female varsity athletes, I think was a very bad mistake, because it overlooks the fact that males and females might have different interests. And it overlooks, the fact that education and intercollegiate sports are not allied. They are usually in strong opposition. It's been a really bad development for the education of women.
Yeah, it's interesting. I mean, we do have this debate a lot at IWF because, IWF took a strong position in the early years against the cutting of male teams to create female teams to comply with Title IX. And of course, I think everybody agrees that, you shouldn't ask one group to step aside to make room for another. I think most people agree that that was not good. In my personal view, I think the colleges are at fault because they didn't want to increase the share of the athletic pie. Now, you might not think that they should increase the share of the athletic pie. I personally think that the best way for them to have complied with the athletic regulations of Title IX would have been to add women's teams without cutting the men's teams. The interest and ability discussion is it's interesting to me. Sports are at universities are unlike anything else. When you're talking about Division I athletes are recruited for. So it's not really about the interest and ability of the student body that you just happen to have or that you admitted. You will have the interest and ability that you recruit for. And so the interest and ability test doesn't really work when you're talking about recruited Division I athletes.
Yeah, I agree with you. That, and this was the basis of an important suit in the First Circuit called Brown versus Cohen. And what the Title IX regulations have really done is say that even if you want to preserve your male teams, then you've got to do a lot more recruiting of female athletes in order to get the number of varsity athletes and number of teams, which means, this is the point, I probably do disagree with you a bit here, I think, which means that you have to spend more money on sports. You have to spend more, the most precious thing that elite colleges have, which is admission slots, on athletes. And which means that there are other females, might be good mathematicians or political scientists or cello players, who don't get admitted because there's a real limit on how many slots there are.
In the interest of full disclosure, and I feel like as a lawyer, lawyers were constantly doing this on this show, but in the interest of full disclosure, I have two daughters who, one currently plays field hockey in college, the other did. They were both recruited athletes, and There may very well have been girls who were better mathematicians than they are, but they were excellent students and highly qualified for their university.
I'm sure. In full disclosure, I'll say that my daughter was a lacrosse player, wasn't recruited, but she loved playing JV lacrosse at an Ivy League school. And I'm a very strong believer in athletic opportunities for women. And the other, I just will mention one other thing about the way in which the focus was on colleges and varsities. I think the biggest problem in inequality has been at the high school level. And only very recently has OCR paid any attention to high schools, where often the difference between the opportunities for men and for boys and girls is really quite profound. And that's when you want to get girls interested in athletics and getting involved in staying in better physical shape. And there are very big racial differences in the opportunities that are given to girls in high school as well.
Can we take a step back here before
Sure.
we get too deep in the weeds in terms of athletics?
Sure.
And could you give us an overview of how we are taught, how we got in the first place from this one sentence to balancing male and female teams, right? What is the regulatory mechanism? What's OCR, right? I want to give background on for folks who don't who may not understand how like the administrative state actually works in this way. So all these things that we were talking about, whether it's athletics, we'll get to, you know, due process and sexual misconduct, we'll get to free speech, right? And we'll get to the question of the definition of sex. None of this is taking place on the statutory level. Like none of this stuff, we just showed you what Congress passed, that one sentence. So could you explain for folks a little bit, you know, how we ended up with all these layers of policy spun out of that single sentence?
Sure. When Congress passed the law in 1972, the term sexual harassment was not being used. It was really kind of invented a few years later by feminist activists and scholars. So they weren't thinking about sexual harassment. The idea that in 1972, Congress had any idea that this would involve transgender issues, no one had any idea. So how did this all evolve? And I describe it as a term I call institutional leapfrogging, which is that the agency takes a small step, and then the courts would take another step, and then the agencies would go one step beyond that, and so on, and so that you ended up with a set of guidelines that really no one had planned for, and Congress had no input into. And I don't think that anyone in the process had any idea where this was going. That's most evident in the sexual harassment.
To take an example of what you mean when you say institutional leapfrogging.
Sure.
So Title IX prohibits discrimination on the basis of sex. And so does Title VII, right? It prohibits employment discrimination on the basis of sex. So different cases go up to the Supreme Court, and the Supreme Court says that in some circumstances, sexual harassment can be a form of sex discrimination when it alters the conditions of a person's employment. So then by leapfrogging, you mean that then the agency comes and says, okay, well, the court said this about employment law, we're going to add to that and say it about Title IX. And then the court comes back and goes one step further than that, and the agency goes further, and they keep hopping over each other in terms of substantive applications of the law.
Exactly.
Meanwhile, Congress is back at the starting line, but
right, exactly. And one of the features there, as you noted, was that all the sexual harassment stuff all started in the employment context. And then when the Supreme Court said that schools could be liable for sexual harassment by teachers against students, then the school said, we need guidance. So what did OCR do? They said, well, let's just import all of these rules from Title VII, despite the fact, and here the analogy problem comes, that schools aren't always like employment. You're dealing with kids, number one. When you're dealing with colleges, you're people living in dorms. So we took the employment rules and applied them to schools without thinking about how they were different. So that's what the agency did in the 1990s. And then one of the interesting things about Title IX was then the Supreme Court finally heard these issues. And before it had only been the lower courts. The Supreme Court took, I thought, a fairly reasonable reading of the statute and said it has to be extreme misconduct, and the school has to be aware of it, and they have to take reasonable measures to deal with it. But then OCR, the Office for
But actually, not just aware of it. Justice O'Connor's opinion in Davis very clearly said that their actions or inactions have to be so extreme that the sexual harassment, the sexual discrimination is actually being conducted by the school. Yes. So, in other words, if a student routinely complains that she's being harassed by a teacher or another student, and the school repeatedly does nothing, then you could argue that continued harassment is in fact their policy, because they're allowing it to occur, right? So she did not, Justice O'Connor and the court never said, a simple failure to discipline somebody for bad behavior could make somebody liable for millions of dollars in damages.
Absolutely. And she said that you have to have actual knowledge, the school has to have actual knowledge and act with deliberate indifference, or a very high standard. Then on the last day, or one of the last days of the Clinton administration, OCR said, we're not going to follow that. That applies only to liability law. We have another set of rules, and we'll follow the previous rules, which really then laid the foundation for the Obama administration's rules that really expanded that dramatically. So in this case, you really do have this big dispute between the Supreme Court's interpretation and OCR's interpretation. And I mention this because the Trump administration regulations in 2020 stayed much, much closer to the Supreme Court's interpretation. And for that reason, I think the Biden administration is going to have a tough time getting any huge changes through judicial review, because the great advantage the Trump administration had is, number one, they went through the whole process and not just through dear colleague letters.
Right.
And second, just like they stay close to the Supreme Court.
That process a little bit of dear colleague letters versus rulemaking, and what power does the department actually have over schools to enforce these interpretations of law that have not been authorized by Congress, and in some cases or even by the Supreme Court?
Yeah, this is one of these kind of seemingly boring matters that is really important. So the statute gives the Office for Civil Rights the opportunity to issue rules and regulations to interpret and enforce the statute. That is what the agency did in 1975, went through the administrative procedures, notice and comment rulemaking process, proposing a rule, getting comments, and then issuing a final regulation in the Federal Register. But they didn't do so again in a major regulation until 2020. So all of that time, they issued guidelines. They issued these things called dear colleague letters, acting as though the head of the Office for Civil Rights is my colleague as a teacher. And most of us do not consider Catherine Lehman our colleague, but she clearly does. So there was no process, there was no public participation. And the other thing that diverted from the statute was there was basically no effort to terminate federal funding for non-compliance. We as teachers are told all the time, oh, if you do that, they'll take away our federal funding. Nonsense. They never do, because it's too politically extreme. The total number of terminations of federal funding under Title IX since 1972 is zero. How do they enforce it? They enforce it by having private parties bring suit in federal court. And then the extent to which the courts then will accept these dear colleague letters and these guidance, then it can be enforced through injunction or through monetary damages.
Well, and also, don't they investigate?
Yes. So that's the other thing for athletics, this suit for damages and injunction was was heavily used. But when you have this disjuncture between what the Supreme Court's saying and what OCR is saying, then that is really foreclosed. So they came up with this investigation strategy. So we will announce publicly damaging, reputation damaging investigations. These investigations will go on for months and often years. They will be extremely expensive. We will build alliances with Title IX offices within these universities. It will basically beat the university into submission until it signs a consent decree. And that's what the Obama administration did after 2014 in university after university after university.
And they do this on the K-12 level as well, right? In slightly different ways. So there's a huge school discipline issue that was essentially the result of a Dear Colleague letter from the Obama administration. They're right at the end of the Obama administration, they put out another Dear Colleague letter that actually did, ask public schools to quote unquote accommodate gender identity, meaning assign kids to locker rooms on the basis of their gender identity or proclaimed gender identity. So
actually,
Dear Colleague letters can have really sweeping changes.
Yeah.
I sort of disagree with your characterization of that, Inez, because if all they were doing was asking them to accommodate transgender students, then a single person bathroom would have been sufficient. That would have been a reasonable.
Right. There was the one case where they pushed back against the school even for creating like a single stall restroom for this kid to change in. But that's how they characterized it.
I'll just say on the transgender thing. I mean, that was a classic case of leapfrogging, because the agency didn't do it. Had a case complaint before it. It was involved Gavin Grimm in Virginia, and the transgender activists got a minor official in the Office for Civil Rights to issue a letter. Not a regulation, a letter, basically saying that we think that Gavin Grimm was being discriminated against. The court then relied upon that, and then OCR, in issuing this Dear Colleague letter, then relied on the court decision, and now court decisions have relied on the Dear Colleague letter, and it's really a game of telephone.
Right. So on that note, I think we should bring in Candace Jackson, who was one of these bureaucrats at OCR, although not necessarily one of the evil, nefarious ones.
One trying to actually bring the interpretation of Title IX something closer to both what Congress and the courts had, sort of laid out.
We did our best to at least, if we were going to send out some kind of guidance or letter, we at least tried to reframe it as "Dear Educator,"
not your colleague.
Colleague.
So Candace Jackson is a lawyer and former deputy general counsel at the Department of Education. As we said in the intro here, she was one of these folks in OCR who was dealing with these regulations. And Candace, if the first thing you could do for us, could you lay out the changes that the DeVos department actually issued, and as the professor said, right, actually went through old school APA notice and comment rulemaking on, which is why it's taken this long for the Biden administration to try to unwind it.
Yep, that's exactly right. And Professor Melnick's history of Title IX lays a perfect groundwork for that. And so you can tell that for about 2 decades, once sexual harassment had started being a sex discrimination thing in the courts, and the Department of Education caught on to that, never bothered to regulate about it, though. Congress never bothered to add to the Title IX legislation to address sexual harassment. And the Department of Education never bothered to issue legally binding regulations. So for about 20 years, it was this political football of guidance documents. And each administration could come in and tinker with the guidance documents. And but overall, the approach of that guidance from OCR for 20 years stayed relatively consistent in terms of having just imported from Title VII, like Professor Melnick was saying, not giving, in my view, a lot of thought to not only what the Supreme Court was saying in the late 90s about what Title IX means for sexual harassment in schools and how that is different from the workplace context. and also not caring that we were importing a huge paradigm, an important, significant paradigm of a new realm that we expected schools to act under, and yet we left them in a gray zone legally as to what is truly required, what is concretely enforceable as a regulation or a statutory obligation versus, dear colleague, we think you should do this. And it's a gray area that really was unfair to schools on something this significant. So by the middle of the Obama administration, they issued new guidance documents that really ramped all of this up in terms of Title IX, because it changed the framework, again, through guidance only, but it really did change the framework to very openly become motivated by being pro survivor. I don't know how else to put it. That was the goal. It was guidance to schools driven by, we think that sexual harassment and assault in schools is still being swept under the rug too much. Survivors are not getting justice. They need to be able to rely on their schools. And so what was laid out at that point, without any public input or process to it, ended up with a lot of very, very one-sided things when these situations, when you think about it, until like Jennifer said, unless you're in a situation where a school is being so deliberately indifferent to a horrible situation that you can really say the school itself is subjecting a student to sexual harassment or assault. But in most of these situations, you're not talking about this is school policy. No school policy did or does say, we support sexual assault. It was a matter of, are there two individual independent people in the school's community? And what happened between these two people? What factually happened? Was there harassment? Was there assault? It's a factual question. And so schools are in a position of having to be kind of neutral in at least seeking to discover factually what did happen. Does it constitute sex discrimination because it is interfering significantly on the basis of sex with somebody's opportunity to access their education? And then separately, what do we do if someone is found responsible of that kind of violation? Then what do we do to discipline that student or employee? But all of that was done under a different framework under the Obama administration, where schools were told via guidance to set up a very short circuit system of any kind of recognizable due process. So it made it very, very easy for schools to go from accusation to punishment. Mm-hmm. And that, in my view, has never, ever served victims or perpetrators well, because this is a serious thing, and this is something that the consequences of getting it wrong are so high on both sides. You do not want innocent people to have their lives ruined by the accusation and losing their education, and you do not want people who have been victimized to fail to get institutional support and whatever kind of administrative justice can be had through that. By the way, it's important to realize, because again, with the pile on and the leapfrogging, it's easy to forget that Title IX is sort of one of three avenues for dealing with severe sexual harassment or sexual assault, criminal acts, especially on campuses. Victims always have an option to privately go into civil court directly against the perpetrator and have the right to pursue criminal channels too. So what we're asking schools to do is happening potentially alongside one or even two other separate legal processes. So you really have to be thoughtful, I think, about what kind of system makes sense for the school environment, both in a K through 12 setting and at a college setting with young adults. But you have to try to set up rules for how a school is supposed to, one, find out about a sexual misconduct incident or allegation of one. And then second, what exactly is a school supposed to do? What actions must they take? The Supreme Court was not helpful in that regard. All it said was, don't be deliberately indifferent. Well, what does that mean? Launch an immediate investigation? Kick somebody out? There was very little guidance in that regard. And then three, how is the school supposed to procedurally deal with determining what happened between two people?
It's always seemed to me, I mean, sexual assault is a crime. And it seems to me that, decades ago, the pendulum has swung from one extreme to the other. Decades ago, people who were assaulted were just brushed off when they went to school administrators about it, and they didn't do anything. Now it's gone in the other direction, but it seems to me that really colleges and universities shouldn't be in the business of determining the facts of an alleged crime. And, why isn't there sort of a bright line rule where if a student comes to an administrator and says, I've been sexually assaulted, the administrator provides supportive services, helps the person report that crime to the police, and then lets the police investigate. And I sort of think there should be a bright line. If somebody is arrested for a crime of sexual assault, they're out. If they're found not guilty, they can come back. But if you're arrested, if the police think that there's probable cause to arrest you for sexual assault, bye-bye until it's resolved. I'm fine with that. But why are we letting the university make those factual determinations?
Oh, Jennifer, there are so many reasons for it. And trust me, when we first started in early 2017 looking at this issue, absolutely it was on the table conceptually to stand back and take a look at what are we doing here? Should we go down the path of let's get specific about what schools need to do, or should we go down a whole different fork in the road and say, this is not school's responsibility? And I'll tell you, the reason we went down the former instead of the latter is because as an agency, as an executive branch agency, we are kind of stuck with what our authorizing statute plus a Supreme Court interpretation of has to say. And sexual harassment, including sexual assault, can be a form of sex discrimination. So we're a little bit locked in that way. Congress could modify Title IX and do a lot more nuance and a lot more setting up a better overall system for the entire problem of this. Title IX, as written, was never intended to be an anti-sexual assault law, right? And so there is definitely a mismatch going on that we're now kind of stuck doing the best we can with as an agency. Can
I say? I mean, there are various types of sexual misconduct that are not criminal. So if I, as a teacher, basically told female students that they had to sleep with me to get an A, then that's fairly serious misconduct, and I should be disciplined by the school.
The other tricky thing these days is that there was a real trend starting around 2011, probably picked up a lot around 2014, but a real trend on campuses to redefine by expansion what consent means in the context of sexual assault. And that change did not happen in parallel with criminal law.
Right.
And so what a school policy deems sexual assault, including rape and any of the other forcible or non-forcible sexual offenses like that, could very well be different and not qualify under that state's criminal law. For those who don't know, the difference is on how to define consent. Basically comes down to, do you judge consent under kind of a standard of no means no, or do you judge consent under a standard that's more what we call affirmative consent, where if you don't get a very obvious verbal yes, you're stuck in a world.
Some of them are even worse. I think I forget, but it was an Ivy League school that had a policy that said if you had felt emotionally manipulated into sleeping with somebody, that you had been assaulted. I'm like, hello, every man tries to emotionally manipulate women into sleeping with them. It's called seduction. This is how it works.
Candace made an interesting point where I just wanted to build on it. She said that there was a paradigm shift in the 2011, 2014 guidance. And I think that's quite true. And the shift was from seeing this as sexual harassment as a type of individual misconduct that's conducted by a few bad apples, and we should punish those people and get rid of them. And I think most people would say that's definitely true. Two, the problem that the purpose of the regulations and the guidance is to change campus culture, to change the culture, which means you have to change the way people think about sex, sexual relations. You have to change people's understanding of what consent is, what power is. So that paradigm shift was really profound in the Obama administration.
Absolutely. Yeah. And in the 2020 regulations, we did return in significant ways back to a more individual paradigm on the theory that each and every individual in these terrible situations matters. Each person involved on both sides of these things, you need to get it right. And so this wasn't about using an allegation that arises out of a particular incident to make a point about the systemic nature of this or that problem. That's not fair to the individuals involved in each awful situation. So we did focus on creating a system where each individual complainant, meaning anybody who is reported to have even allegedly suffered serious verbal harassment or any kind of sexual assault on campus, immediately the school is supposed to reach out to that person and offer educational supports. We call them supportive measures, things a school can do to try to deter sexual harassment, protect everyone's safety, and hopefully help a complainant's education stay on track. Then we gave autonomy to the complainant, the alleged victim, to have a lot of choice over whether to then file a formal complaint that demands that the school factually investigate and potentially punish. The school's Title IX coordinator has the authority to basically override and do it anyway. And we felt that was necessary as a stopgap to the way that, especially when it's professor student or teacher student or so forth, a lot of times students do not feel comfortable filing their own formal complaint. So the school, through the Title IX coordinator, can do that. But a lot of the autonomy is returned to the individual alleged victim. And that is one of the powerful things that can help heal, is giving that kind of control back in that way. Then what we did with the regulations is say, okay, if the school through the Title IX coordinator or the victim, and if the victim's a minor, by the way, it can be all through the parents, chooses to file a formal complaint, then we set out exactly what a school has to do then. They have to conduct a neutral, impartial investigation. They have to use an investigator who has training on Title IX and training on how to remain impartial in these situations. That investigator has to collect evidence and then show that evidence during the investigation to both parties, each of whom has the right to an advisor of their choice to accompany them throughout this process. And each side gets to weigh in on that evidence, propose witnesses and evidence and so forth. And then at the end of the investigation process, both sides and their advisors have the opportunity to submit questions to the other party. At the K through 12 level, that just has to be done through written questions. But at the college level, there's going to be a hearing where through the party's advisors, you pose questions that maybe test the plausibility of either the accusation or the denial. I'm a big proponent of cross-examination and truth-seeking like that in a factual way being of equal compelling benefit to both sides in these situations.
I think a lot of people are familiar with how some of these, and I will call them what they were prior to the regulations advanced by the Trump administration, these kangaroo court sort of trials. I think most people became aware of how this works when Kavanaugh was accused, even though it was in a totally different situation. It was politics. It was his, sort of court was both the court of public opinion and then the Senate, right? But I think one of the most persistent, frankly, lies that I've seen about the regulations that you put out was that, the Trump administration is making it so that if you're a victim and you file a complaint, your the person you're accusing of sexual misconduct actually is going to cross-examine you personally. And I think that was just one of those. It's very much more like what happened even in the Senate quote unquote trial for Kavanaugh, where the GOP had a lawyer come in and say, okay, well, where were you on Friday at 8? Okay. And then who did you talk to after that? Yeah. And then, are there any other witnesses? Did you say something to anyone? Did you come home? Like very basic fact finding missions. Yeah. As you say, it's so critical to being able to figure out in some of these very ambiguous he said, she said situations, that tool is really essential to giving any modicum of due process. I did want to ask you before, since we are running out of time here a little bit, I wanted to make sure to ask you, Candace, about the harassment part of your regulations, right? So we touched on it a little bit in the beginning of the program, that actually there's this whole free speech component as well to the way that schools were trying to implement Title IX and the way that previous administrations through Dear Colleague letters had encouraged them to do that, that really broadened the definition of harassment to a point where it could really scoop in some protected speech. So if you would both maybe address that before we come to a close here.
Sure. Yeah. That's been a huge issue and something that I think we reached the right balance with in the 2020 regulations. And that is realizing that non-physical harassment based on sex, you're talking about speech, you're talking about verbal, maybe graphic, or, but you're talking about expressing words or something of that nature. It is going to implicate speech. Students do not discard their First Amendment rights, nor do teachers or professors when they walk through the schoolhouse gates, right? And so if you allow harassment to become so broadly defined the way it was under the Obama administration, literally so subjective, anything that is subjectively unwelcome, when you apply that to the realm of speech, all of a sudden you're in a zone of shutting down and deterring and punishing an awful lot of expression of opinion. When you're talking about younger kids, there's banter and social interactions that kids are kind of fumbling through. When you're talking about
all of high school was unwelcome speech to me.
Right.
You really want to get down to it.
You have to allow some room for that in the educational environment in a way that you don't necessarily have to in a workplace. I am totally cool with banning, sex-related talk in a workplace. No problem. School has a different context. When you get to college level, it's actually critical that people be able to talk and write and speak freely about issues that are going to be subjectively offensive and unwelcome to a listener.
I just that one of the features of the Obama guidelines was they kept referring to verbal conduct, which is speech, and the fact that they kind of equated speech with action was part of the problem. And they said it doesn't have this misconduct through speech doesn't have to be aimed at anyone in particular. It can be political speech. And if you want to see examples of this, Laura Kipnis at Northwestern was harassed by writing an article, engaged allegedly in harassment by writing an article in the Chronicle of Higher Education. And so political speech could subject you to investigation. She's just written another article in the Chronicle of Higher Education I really recommend you read about the danger all this creates within academia.
Yeah. So what we did is try to fix that by dividing up the definition of what kind of misconduct or what kind of conduct can qualify as sexual harassment, broke it up into the quid pro quo, teacher-student stuff, the sexual assault, which includes dating violence, domestic violence, stalking, and then that middle category, we put the same standards into that category that the Supreme Court laid out in the late 90s for school sexual harassment. And that is, you're talking about, let's say, verbal, unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that you can conclude it is really denying someone equal access to education. If that's the standard, that is about right to filter out where the bounds of free speech, even in an educational environment, are going to kick in.
So just to illustrate, I mean, what the Davis v. Monroe standard, or I think what people were thinking about when they thought about sexual harassment in the context of becoming so ongoing, severe, pervasive, and objectively offensive, was, the school not stopping, for example, someone from following a female student around, like a man following a female student around, and, calling her the C word repeatedly, like walking around behind her as she was trying to go to classes, and the school didn't do anything about it, right? That might raise the level that you're talking about. But as Professor Melnick just mentioned, I mean, that has completely, first of all, it's unimaginable that in today's context, a school would tolerate that. But now we're talking about an article in a journal that is generally addressing topics of sex, of gender, of all of these debates that Jennifer and I are always having on this show. A lot of that speech could be subjectively offensive. So much of the conversation that is worth having is subjectively offensive to someone. So it really has expanded far, far beyond what people would typically think of as sexual harassment.
Right. And
I'll give you an example of how this happens on college campuses these days. I wrote an editorial in the school newspaper about freedom of speech and why it was threatened on college campuses. One student group said my entire article was a microaggression. Which I guess meant that it should have been canceled and censored. That's where we're at college.
Well, and those of us who are actively engaged in the sex versus gender identity issues right now have to be very aware that when the Biden administration is proposing right now to amend these Title IX regulations to make on the basis of sex discrimination include gender identity, when it comes to free speech, that's a huge concern, because we are in the middle of a significant and crucial public and social debate and discussion over these issues right now. And in my view, if you allow that change to be funneled through Title IX, you're going to shut down that debate via sexual harassment of all things. You could actually be deemed a sexual harasser and get expelled on that ground for talking about and voicing a perspective that says, I don't believe gender identity is objective enough to override sex-based classifications when it comes to sports or anything else. You express that, now you're offending somebody on the basis of gender identity. You're the discriminator, you're the harasser. It's not good.
Right. And so it's basically the confluence of two things: the expansion of the definition of sexual harassment and what counts as something so offensive that it impairs the educational experience. It's the combination of that expansion with a new expansion, which is expanding the legal definition of the word sex to encompass gender identity. And when you put those two expansions together, it's really, really dangerous for free expression. There are already universities that have, as part of their Title IX policies, saying that misgendering somebody, using the wrong pronoun repeatedly, is a form of harassment. Whether or not it's a mistake or deliberate, it can be counted as sexual harassment by some universities. And the Biden administration is about to codify that by regulation. I do want to talk about the forthcoming regulations. We don't know exactly when they're going to drop, but our understanding is that they will both repeal the DeVos due process regulations, which were so important, and usher in new substantive rights that are not were not anything Congress thought about in 1972 when they passed the law. Preview that for us a little bit and kind of survey the different buckets of things that we think they're going to do, Candace.
Yes, this what the Biden administration has said so far is exactly that. They want to roll back the due process protections that are built in. They want to re-expand the definition of what counts as actionable sexual harassment. And then third, they want to add in the concept of gender identity discrimination as being the equivalent of on the basis of sex. They've already issued guidance. They did this last summer, that a fact sheet that they issued, Ed issued jointly with the Department of Justice, that gave some helpful illustrations of the way that the departments are already reinterpreting Title IX. This is before they've bothered to go through regulations. They're already reinterpreting Title IX to label it gender identity discrimination, to require somebody to adhere to a single sex designation. It's one thing to say, don't discriminate based on whatever characteristic you want, in terms of don't kick somebody out of school just for having that thing. Don't tell that person that they're excluded from extracurricular activities, or, that's punitive based on some characteristic. Okay, that would be one thing, but they're stretching now the concept of discrimination to really invert it and stretch it so far it's meaningless, in the sense that it's considered illegal discrimination not to honor someone's belief, someone's inner sense of themselves. That's not something we've ever done in law before, and there should be huge red flags and problems about that.
So we've expanded the definition of harassment. We've expanded the definition of the term sex. Now we're expanding the definition of the word discrimination. Okay. Let's just blow the whole thing up.
Yeah. Well, I will say that I think the Biden administration is going to have a tough time coming up with regulations that will survive judicial review to make wholesale changes in the 2020 regulations. Because I think, number one, the courts are concerned about due process. Many courts, and schools have lost a lot of suits. Number two, they stuck so close to the Supreme Court. So I think, if they make some minor adjustments, that'll get through. Major adjustments, I don't think. So I think the real battle is going to be on the transgender issue and not so much on the sexual harassment.
I think in the middle run, over the next 5 years, I think that's right.
All right. Well, I think we're running out of time here, unfortunately, although there's so much to talk about with this one sentence, just to, loop it all back together, right? We've talked about sexual harassment. We've talked about free speech. We've talked about gender identity. We've talked about sports, and we've talked about due process. And all of this has been spun by the regulatory state out of this single sentence in Title IX. But Candace Jackson, right? Sorry. I just remember you as Candace. Candace Jackson, thank you so much for joining us on At the Bar. Professor Shep Melnick for Boston College, thank you so much also for joining us at the bar. And we're just going to, Jennifer and I are going to wrap up, just the two of us, wrap up this. So we'll excuse both of you from this class at the bar, but thank you so much for joining us, for enlightening us on this. And definitely, Jennifer, do you want to read out the professor's book again?
It's The Transformation of Title IX, and it's available it's published by Brookings.
Highly recommend, by the way.
Oh, thank you. Thanks for the ad.
So thank you both for joining us.
Thanks.
And just to chat up with Jennifer at the end here, I wanted to point out that actually here at IW, in IWV, we've released, again, we mentioned it last time, the Women's Bill of Rights, which, because we've been talking about all of this, very important, these very important policy changes that are happening through the regulatory state, none of this is happening via legislation. And I think my favorite part of our Women's Bill of Rights is that it actually encourages legislatures, whether at the congressional level, the federal level, or at the state level, to actually go ahead and define sex, to make sure that, especially that gender identity piece of this battle, actually does have to happen in the court of public opinion through elected officials, where we as citizens get to weigh in and discuss it, and not sort of through a dear colleague letter that gets thrown out there by an administration that ends up changing the entire landscape, and yet not giving people any opportunity to really weigh in the way that they would in the traditional political process. So Jennifer, I don't know if you want to talk a little bit about our Women's Bill of Rights and how that prevents this sort of regulation from happening.
The Women's Bill of Rights would just codify certain words, words like sex, woman, female, so that they can't be twisted to mean something other than what they commonly meant at the time that they were put into certain statutes. So it doesn't prevent legislators from passing new civil rights protections for different groups. It simply forces them not to do that through the back door by twisting pre-existing statutes. And as you said, it forces the discussion into the public, and so that it's not behind closed doors. Because I think that when it's behind closed doors, I mean, it's bad for democracy, but it's hurtful. It's hurtful to the culture generally when we twist words like this, right? Words have to have meaning. And so we have to have a common understanding in this country of what on the basis of sex means. We have to have a common understanding of what things like sexual harassment means. We don't get into that in the Women's Bill of Rights. But again, a common public understanding of certain terms is critical for the rule of law. If we can't agree on what the words in our laws mean, the words cease to have any meaning at all. And that's really, I think, scary.
Yeah, I completely agree. There's this sort of Orwellian tinge to the entire conversation to be had around Title IX. And I have to keep reminding myself that and that's why I brought it up like 3 or 4 times during the last hour, has been, this is just one sentence that bans sex discrimination. All of this stuff that we've been talking about, all of these policy buckets, they come back down to one sentence that Congress passed in a time where there is no way that they ever would have considered the implications for gender identity, right? And so I think it's really important to keep bringing it back. Now, this Title IX discussion is going to be ongoing. I think we're actually going to continue this discussion probably in our next At the Bar in 2 weeks, because there are so many different buckets, and we have a special guest as well, who we hope will be coming on. I won't share that right now, but we'll have a special guest coming on to discuss both the regulations that Candace mentioned and elaborated on for us, the regulations promulgated by the Trump Department of Education, and then the current speculation about when. So nobody really knows when these new regulations from the Biden administration are going to come out. They previewed them by linking to the Washington Post. So we know some of the contours of what they're thinking about, but there's still a very open question what the response will be from the public, what the notice and comment period is. And I want to really encourage people when that does come out, really consider writing a comment, because there is a public sort of notification and comment period where your voice actually is very important. And it's not just a foregone conclusion, because at bare minimum, if all of you guys write in about all of these issues, somebody in the department is going to have to spend their time to go over each and every concern and substantively address it, or the regulations can be struck down by court. So it is really like a very important way to make your voice heard. So I want to encourage everyone in advance that when they do drop these really damaging regulations that really are going to transform this single sentence into a behemoth of, frankly, lies and policies that are not supported, I think, by the majority of Americans, this is your opportunity to have your voice heard. It's not quite as good as voting for someone in Congress, which is how it's supposed to work, but it's at least better than a Dear Colleague letter. So,
yeah. And I would argue to push back against it now where you can, because the reality is these regulations haven't dropped yet. They have the force of law. They've just been previewed to the press. And, if you hear a teacher, an administrator, a member of the media suggest that certain policies are required by Title IX, push back, because Title IX requires that there be no sex discrimination. Title IX does not require any number of things that people are claiming it requires now, and that the current administration is suggesting that it requires. So until the regulations drop and they have any legal force whatsoever, don't let people suggest that this is the law. It's not.
That's a really good point to close out on, Jennifer. And just for everybody's edification, if you haven't watched At the Bar before, it's a production of the Independent Women's Forum. It's also available for viewing on Facebook, YouTube, and IWF.org, or you can listen to it in podcast form on iTunes, Spotify, or iHeartRadio, anywhere you really get your podcasts. At the Bar is there. And Jennifer, you want to close us out with the last line here?
Sure. We hope you'll join us in 2 weeks for another spirited discussion of issues at the intersection of law, politics, and culture. Until then, thanks for joining us.
Cheers.